Welcome, everyone. Thank you for joining me today for the nuts and bolts of Medicaid Workshop. My name is Christine Oyler, and I'm the Director of Medicaid here at Bellomo and Associates. First, I would like to start our workshop today with telling you a little bit about our purpose for why we provide these free workshops to you. Attorney Bellomo and our team here at Bellomo and Associates truly feel that education is one of the top things that we can do for our prospective clients and existing clients. We want you to understand the process that you are about to go through, so we feel that it is valuable for you to attend and receive this knowledge so you have a better understanding beforehand as to what you will be going through with the Medicaid process. A little bit more about our purpose and why Attorney Bellomo feels so strongly is a couple weeks before he was taking the bar exam, he got a call late at night that his mom had collapsed and was rushed to the hospital. So he and his wife got up and went to the hospital to see his parents. And they realized that mom at that point in time was being diagnosed with cancer. The surgeon came out to talk with the family, and they talked about obviously the surgery that was going to be needed. They talked about after the surgery, chemo, radiation, what the different things would look like for treatment. They talked about, would mom be able to go home from the hospital, or would she need to go to a rehab facility or to a long-term care facility? And they asked the doctor, the surgeon, questions. Well, what happens if she goes home? How do we pay for care? What happens if she needs a nursing home? And the surgeon said, I don't know. You need to go talk to an attorney about those things. So Attorney Bellomo made a consult to see an attorney in the Pittsburgh area, and he went and he was told, well, you have to pay $300 to see the attorney. And before you see the attorney, you have to pay the fee. So he paid the fee up front, met with the attorney, and the attorney listened to him and his situation. And he said, well, I have answers for all of your questions and a solution to your problems. But if you leave today, you forfeit the $300 that you've already paid our office. Attorney Bellomo had no answers, didn't like that, so he left the office and forfeited his $300 and said, I'm going to go see another attorney. Well, he did just that and paid another $300 and was told the same thing. He had no answers after 2 meetings with 2 different attorneys. His mom woke up and the family was in the hospital, and they said, well, what did you find out? How can we protect our assets? What's going to happen to the house? How are we going to pay for the care? Attorney Bellomo said, I don't know. He didn't have answers after going to 2 different attorney offices. And his mom said to him then, Jeff, when you're an attorney, don't do that. Don't let this happen to other individuals in this same situation. And so that is one of the bases for why Attorney Bellomo feels so strongly about education. Also, with that being said, a lot of Medicaid clients wish they would have known what was going on ahead of time so that they could have been more prepared. And so between those 2 items, we developed the Medicaid Workshop, and that we will now present to you today. You should have received via email a virtual booklet or handout folder. And inside, it contains different pamphlets talking about our attorneys specifically and what specifically a certified elder law attorney is compared to any type of attorney. Inside the folder, there are other handouts, such as who needs estate planning and some facts regarding that. It also will talk about POAs and Medicare and Medicaid and the facts regarding those, and Medicaid planning. So those are all something that you should have received virtually. Okay, next, what did you come to learn today? Well, if you came to learn how to sue your neighbor, get a divorce, you're at the wrong workshop, and you need to ask for a referral for another attorney's office, and we can help you with that. But if you're here to learn about Medicaid, the nuts and bolts of Medicaid, you have attended the right workshop and you have the right link for today's purpose. The first portion of today's meeting will be the Medicaid legal portion, and the second part is the nuts and bolts and preparing the Medicaid application. And specifically, what do you need to get prepared? What documentation and things like that are needed? A little bit about our team here at Bellomo and Associates. The top left-hand picture is our overall team, but we had to add in a few new hires. And at the bottom, you'll see Lauren and Michelle and Marjorie. And at the top right is Attorney Bellomo and Attorney Hill. So just some faces for you to recognize. When you come in the front door, Lauren is going to most likely be the one to greet you and take your documents and help you find the right place for your meeting. And then you will possibly eventually be meeting with Attorney Bellomo, who is on the far right, or Attorney Hill, who's on the left of that picture. Introducing our Medicaid department. I am one of the Medicaid coordinators. Again, my name is Christine Oyler, and I have a background in nursing. I'm a registered nurse, so I have that knowledge of what you may be going through when you are in a hospital or long-term care setting. The top right is Deb Vyeth. She has a background in asset protection, so she helps us a lot understand that portion of the Medicaid process. The bottom left is Lisa. Many of you will talk with her to schedule appointments, and she will help figure out what type of meeting you need, whether it's estate planning or more specific to Medicaid. And then Sherry is on the bottom right, Sherry Bishop, and she is also one of our Medicaid coordinators, and she comes to us from being a caseworker in the county assistance office reviewing Medicaid applications. So she has a wealth of knowledge on what it takes to get approved and whether this will meet a regulation or not. So again, between all of us, we have an overall well background department to help you with the Medicaid process. So with Medicaid, there is pre-planning potentially that was already done, or you may be in crisis planning. And what is the difference? Well, in pre-planning, you see a gentleman in a hammock relaxing, sipping on a drink. He's in paradise. And then there's a gentleman on the other side pulling his hair out. And so that's more of crisis planning. And what is the difference between the two? Well, pre-planning means ahead of time, before your loved one was ill, or more than a year at least, you were planning, and you were looking at your estate and maybe getting your POAs completed, your will. Maybe you were doing some trust and putting your assets inside a trust. And what does crisis planning mean? Crisis planning is more so when it's more imminent that you're going to need care. Within probably the next year, you yourself, your loved one, is going to need either care to be brought into the home or for care in a long-term care, skilled care facility. And so a little bit about the two differences is in estate planning land ahead of time, none of us have a crystal ball, but we can always plan, and maybe we don't suspect anything's going to happen. We're overall healthy and life's good. And so we think, okay, there's a 5-year look back period for Medicaid to look back and see what you've done with your assets in the past 5 years. And you and your spouse are healthy and everything's fine, and you're going to do your estate planning. And so you do that, and maybe you do a trust and you fund a trust, you put your assets inside of a trust. And we do offer workshops that is completely regarding estate planning. And so if you are in the pre-planning stage, I do encourage you to attend that workshop. But if you are in the pre-planning stage, maybe you did a trust. And so you're going down the road and everything was great. And all of a sudden you have a stroke. Well, what happens? Well, the attorney's going to figure out what you need to do and where you are from when you funded that trust. If you made it 2.5 to 3 years from when you funded the trust, that could be beneficial. If it's been less than about 2.5 years from when you funded the trust, what does that mean? That means we're just going to kind of back down that pre-planning route, and now you're in crisis mode, so we're going to go the crisis route. So there's really no harm, no foul. It just means you didn't get really all the benefit out of the trust as you had hoped, but we can still help you. And so whether it's the pre-planning or the crisis planning route, our office is able to evaluate your situation and help you. There are still things that we can do, even if you didn't pre-plan, if you are in that crisis mode, even if your loved one's already in the nursing home, there are things that we may still be able to assist you with. Again, you just need to remember that your loved one does need to be in the state of Pennsylvania in order for us to apply for Medicaid and do these types of asset protection, crisis planning, pre-planning items for you. In York County, currently, an average nursing home cost per month is between $10,000 and $12,000. Quite a bit of money to have to pay privately. So if a married couple both were all of a sudden needing care, imagine paying $20,000 to $24,000 out of pocket. That would add up quite quickly, and a lot of people would be depleting their assets rapidly with that thought in mind. And so many people do want to maximize their options based on that. They want to stay at home as long as possible. They may want to try an assisted living or a personal care home. And if those options aren't possible, then obviously they will look into a nursing home, a skilled nursing facility. Well, how do you pay that $10,000 to $12,000 for the nursing home once you do get to that route? Well, there are multiple ways you can pay. Obviously, one, you can pay privately. Again, $10,000 to $12,000 a month. So, your assets could be depleted rather quickly. There's also the option of long-term care insurance, which will pay for care in the home and care in a nursing home. And that is a great option. But if you are in that crisis planning mode, it may be too late for that option. If you're in the pre-planning mode, it's a great time to look into long-term care insurance. But again, if you are in the more immediate need, it's more imminent that you are going to be placing your loved one, it may not be the appropriate time to start looking into long-term care insurance. There's also the government will pay for your care. And there are two ways that the government will pay. You can specifically think of Medicaid or VA benefits. Now we're going to talk some more about the different types of benefits and what they will cover. So VA benefits is specifically known as aid and attendant benefits. And if you have been a veteran and served more than 90 days, and at least one of those were during active wartime, you did not need to actually be in the war. You could have still been stateside, but you served during that time, you may be eligible for aid and attendance benefits. Also, if you are the surviving spouse of a veteran that met that criteria, you also would then be, as the surviving spouse, eligible for aid and attendance benefits. And aid and attendance benefits will help pay for care in an assisted living facility. Medicaid will not cover payment towards assisted living, personal care, or memory care units. But again, at least a VA benefit would if you would qualify for that. There are a couple other items that need to be covered as far as making sure you would qualify for aid and attendance benefits, and that is your income must be less than the cost of care that you are receiving, and also you have to be medically qualified. You also have to have assets less than $80,000 currently in 2021. Care in a home can also be paid for by the VA. It can also be paid for by Medicaid under the Waiver Program. The Waiver Program is set up to be able to provide care to individuals in the home that meet criteria of being medically qualified for needing skilled care, financially qualified, that meet the income cap for the Waiver Program, and then by providing all of the documentation that is needed still for the Medicaid program. In a nursing home setting, Medicaid will pay for your care once you are qualified. Again, for qualifying in the Medicaid, for Medicaid in the nursing home, you must be medically qualified and financially qualified. There is not an income cap on the Medicaid program in a long-term care facility. So, what is Medicaid? Medicaid is a federal-run program, but every single state sets up their own program, so you can never compare state to state. We here at Bellomo and Associates are able to assist you as long as the individual will be residing in the state of Pennsylvania and receiving the Medicaid benefits in Pennsylvania. If they are in New Jersey or Florida or Texas, we would not be able to apply for Medicaid for them, but we could give you referrals for attorneys that could help you in those locations. Again, please remember, do not compare apples to oranges. Because it is a federal program but run by each individual state, states have different requirements. And so while Texas may have one requirement, it may not be the same in Pennsylvania. And Pennsylvania may have a requirement that's not the same in Florida. So please always keep that in mind. And just when you're talking with other individuals, please just make sure to have a consultation so that you know what your specific facts are and not listening to what others have told you, because it may be a completely different situation for them than it is for you. We like to call getting qualified for Medicaid as a three-prong test. You have to be medically qualified. Well, how do you determine if you're medically qualified? Our office cannot help make that determination. We will tell you to talk to your family physician and see if they feel if your loved one is nursing facility clinically eligible. The Area Agency on Aging would also be able to help do an assessment on you to see if you are medically qualified. Again, our office cannot determine if you are medically qualified, but once you are determined medically qualified, we would be able to help you become financially qualified for Medicaid. So that's really where our office can come in and help you, is to make sure that you are financially qualified or that we can assist you in becoming financially qualified and potentially protect assets for you. Also, you have to have a complete and accurate set of records to prove to Medicaid and the County Assistance Office that you are eligible for Medicaid. So it's not just being medically qualified, it's not just being financially qualified. You do also have to have the proof with many documents to prove that you are qualified. And that's why we call it a three-prong test, because it's medical, financial, and records. So how do you become medically qualified, or what determines if you're medically qualified? Well, this is not a hard and fast rule. It's not a definitive. This is more of just a guideline that we're going to talk about right now. There's something called activities of daily living, or ADLs. And those things are personal hygiene items, dressing, eating, toileting, transferring, and walking. And how well you do those things independently or with assistance or completely dependent. Someone has to help you along the whole step of the way. So for personal hygiene, are you able to still bathe yourself? Are you able to do your own oral care? Or does someone have to help set up your toothbrush and put the toothpaste on because you don't have the dexterity to do so anymore? Or does someone have to completely not only, set up the toothbrush and toothpaste, but brush your teeth and clean up afterwards? So are you independent, needing some assistance, or completely dependent? With dressing, are you able to make appropriate clothing choices and physically dress yourself? Or do you need assistance? Or are you completely dependent to someone help you with that? Eating, are you able to feed yourself still? This does not mean that you have to necessarily cook the meal, but that you are still able to feed yourself. Do you need assistance with cutting up your food, or do you need someone to actually help feed you? Toileting. Do you have capacity still to know that you need to use the restroom? Are you able to get there, or do you need assistance? Or does someone have to make sure that every hour or 2 hours that they're taking you to the restroom? Transferring, are you able to move from a seated position to a standing position on your own, or does someone help you do those things? Also walking, are you able to ambulate on your own? Do you need an assistive device? Or do you need someone to wheel you in a wheelchair? What level of care do you need for those activities of daily living? So, as we just discussed the activities of daily living, how do those activities of daily living, or ADLs, relate to the level of care that is required for yourself or your loved one? Well, if they needed absolutely no assistance with any of the ADLs that we just discussed on the prior slide, they are independent. They do not need care. So they are known as independent living, and they're at home and going about their business. If someone potentially needed help with one or two of the activities of daily living, they may be qualified more so for a personal care or an assisted living facility. And again, this isn't a hard and fast rule. It's a guideline. It's an overview. Our office does not make the medical assessment determination. And so either the physician or the area agency on aging in the county that the individual is residing in are doing those assessments, and they are the ones making those decisions. But this is just a overview, an understanding, a generic understanding. So it's not a guarantee. But overall, if you need one or two, if you need care with one or two of those activities of daily living, that is when you may be qualified more so for a personal care or an assisted living facility. If you need assistance with 3 or more of the activities of daily living, or have a diagnosis of chronic dementia, then you may be more so qualified for skilled level care, and that would either be in a nursing home setting or in a waiver program setting. I'm going to talk a few moments about the waiver program. The waiver program is when Medicaid will pay for an individual to have skilled care help in their home instead of being placed in a nursing home. They still must be determined to be medically qualified. They still need to be meeting the requirements to be nursing facility clinically eligible. And I have sometimes people say, well, I don't want my loved one to go into a nursing home, and you just said they must meet the criteria of nursing facility clinically eligible. We understand that, and we just need them to meet the same level of care needs that they would need to be placed into a skilled care facility. The waiver program then would offer the care to come into the home. They'll make the determination by the Pennsylvania Independent Enrollment Broker and the Area Agency on Aging on the hours that are allotted to your loved one for how many hours of care will come into the home and provide that care for them. With the waiver program, the Pennsylvania Independent Enrollment Broker is notified, and then they send a document to the physician, a certification letter that the physician fills out. They also will be completing an assessment of their own, and they also contact the Area Agency on Aging to complete an assessment also. And so when all of those 3 documents are gathered, they'll be reviewed and they'll make the determination that the individual does meet the medical requirement for skilled level care. And so then that is what determines what kind of care and how many hours that individual is entitled to. With the waiver program, there is a couple different criteria. 1, you have to be medically qualified. 2, you have to meet an income cap. And currently in 2021, the current income is $2,382 of gross monthly income for the individual that needs care. So if the individual that needs care income is below that $2,382, they would be checking off another part of that criteria checkbox list for waiver program. If their income is higher than $2,382, unfortunately, they would not qualify currently for the waiver program. With that being said, please always keep in mind that there is not an income cap in the nursing home skilled level care, long-term care benefits for Medicaid. So it's only in the waiver program, and they're only looking at the individual that needs care, what their gross monthly income is, not in a married case, both spouses. So it's only the individual that needs care. So waiver program, medically qualified, then you have to meet the income requirement, then you have to be financially qualified. So that's the same as in a nursing home program or the waiver program. And then you have to have all the documentation that is needed to whether you're applying for the nursing home program or the waiver program. So I just wanted to take a moment to tell you a little bit more about the waiver program. Who determines if you are medically qualified? Well, again, it's the physician, it's the Area Agency on Aging that's making that determination. It's not our office. Once the medical determination is made, that is when our office would be contacted for the financial piece. So now we've just talked about being medically qualified and making that determination. Now you are determined to be medically qualified. What is the next step? You're not financially qualified, potentially, and so you need to check into that. And that's where our office can come in and assist you. Some guidelines for that currently in the year 2021, a single person whose income is over $2,382 of gross income, meaning before any deductions, may have up to only $2,400 in countable resources. If someone who is single, if their income is less than $2,382 in the year of 2021, their countable resources may be up to $8,000. In a married case, it will depend upon what both married individuals have as far as countable resources. You can't just say this is my wife's and my wife needs care. It's truly looked at on both spouses and what their assets are. And so in 2021, the maximum amount that a community spouse may maintain and be financially qualified for Medicaid is $130,380 and no less than $26,076. And that all depends on a resource assessment. What is a resource assessment? Well, a resource assessment is when either on the day of the assessment being completed for the medical determination for the waiver program or for the long-term care placement on day of admission, in a married case, they will look at what the assets are owned by jointly both individuals or individually the husband and wife's assets. And they will make a determination based off of that what the community spouse, the spouse who is not currently needing care, may maintain, and it will range somewhere between that $26,000 figure and the $130,000 figure. So now you have to think to yourself, well, what happens if I have more than $130,000? Do I need to spend down? And okay, great. I have 150,000, so that means I can qualify as soon as I get to 130,000. That's not how it works. There's a specific calculation that needs to occur, and we will be able to help you figure that out so that you know what you are as the community spouse allowed to keep and still become financially qualified in the Medicaid regulations. Again, please do not compare apples to oranges when you're talking to other individuals, because someone may have been financially qualified as soon as their loved one was placed in a nursing home, but they may have had less than $26,000, and someone else may be qualified and they had $50,000. So it really depends. Please make sure you're coming in for that consultation that you are entitled to by attending today's workshop so that we can review your case. Another item that I would like to mention is related to what the community spouse is allowed to keep. And so we had said about, there's that range between the 130,000 and the 26,000. But what happens if they determined you are allowed to keep, let's just say, 50,000, but your assets of countable resources right now are really 100,000? Does that mean that you have to spend down your assets until you are below $50,000 as the community spouse? No, that is another reason why individuals do retain our services, not only to make sure that they are financially qualified, but if possible, to protect assets. In a married case, we are able to protect 100% of the assets for the community spouse. And in a single case, we are able to protect approximately half of the assets. Again, we have to look at all those pieces of the puzzles in your specific case. You can't compare apples to oranges. We need to truly see what is your fact pattern so that we are able to help you with that analysis as to, what are your current assets? What assets are you able to keep in order to be financially qualified? And is there a way that we can protect assets that are above what you are allowed to keep? And again, that's something that our office is able to help assist with. Now we're going to talk about three lands. Attorney Bellomo coined this term, three lands, to help illustrate the differences between estate planning, tax land, and long-term care land. And over here is estate planning land. And over here in the middle is long-term care land. And then over here is tax land. And so one thing I hope you can notice by these different lands are that they are separated. They are different from each other. And in estate land, you can control what you have. You're making those decisions. You are making the decision to decide whether you are going to give your children things when you pass, if you're putting them in a trust, and what's going to happen to your property. You're in control. Over here in tax land, you can actually be able to give away your assets, and we're going to talk a little bit about that. Your financial advisor, your typical attorney, not thinking Medicaid, but thinking in tax land, they are going to say that you are able to give up to $15,000 away as a gift each year, and there will be no tax implications, and this is known as the annual gift exclusion. So every year you are able to give away $15,000, and you as the individual giving the gift or the individual receiving the gift, there are no tax implications for you. You can also actually, in your lifetime as an individual over here in tax land, give $11.7 million dollars away and not have a tax implication. You, as a married couple, can give $23.4 million away in your lifetime. So not too many people have those assets to be giving away, but in tax land, your financial advisor is letting you know that it's okay to give $15,000. So if I have 4 children and I want to give them each $15,000, I can do that. And there's no issues with that. So I just gave away $60,000 to my 4 children. But now, all of a sudden, I've had a stroke. And I'm winding up in long-term care land. And what's going to happen? I need care. But I just gave $60,000 away. And in long-term care land, there is a 5-year look-back period on what has been done with my assets. What have I been doing? And what are they looking for specifically? They're looking for gifting. And so that gifting that I did, let's say a year ago, it's within the 5-year look-back period, I gave $60,000 to my children away. And now I'm going to be penalized because a gift in long-term care land causes a penalty. Well, now wait a minute, you're thinking. You just told me over here in tax land that it was perfectly fine for me to give away up to $15,000 a year. Or as a married couple, $23.4 million in our lifetime. But now over here, because my spouse needs Medicaid and long-term care and will be placed in that skilled nursing facility, now I'm going to be penalized, but you told me it was okay over there? Yes. Unfortunately, that is the difference between the different lands. Estate planning land, you can make your decisions and know who's, you're going to give things to in your lifetime. You can give things away over here in tax land, which is what most financial advisors and attorneys are thinking about when they are talking with you about your assets and gifting. Most aren't thinking about what happens in long-term care land because they don't necessarily always know. And so unfortunately in long-term care land, that is when there will be, unfortunately, a penalty for gifting that has occurred. Attorney Bellomo also coined a term that a gift is non-take-a-backable. It's a very legal term. And simply what does it mean? It means that once you've given that gift, you cannot necessarily get it back. So you really need to think about, being in control of your assets. People will talk about, what happens with inheritance tax, and shouldn't mom or dad put the house in my name before they pass on so I don't have to worry about that inheritance tax? Well, that's not always the best situation. An inheritance tax is currently 4.5% to a lineal descent, someone, from the parent to the child to the grandchild. To a spouse, currently, inheritance tax is at a 0%. To siblings, it's at 12%, and anyone else, it's at 15%. So if you are the child helping your parents, do some estate planning and thinking, some people consider, well, maybe we should put the house in our names as the children so that we don't have to worry about that 4.5% inheritance tax. And that's not always a positive, because if the parents bought that house for, let's say, $100,000, and when they pass and you inherit that house, well, you would have already had the house, you wouldn't have inherited it. So you would have, not had to deal with the 4.5% inheritance tax. But what happens when you go to sell that house? Your parents bought it at $100,000, and let's say you are selling it for $250,000. Well, you're going to be taxed on that difference because you will have to have the step up in basis, and you will be taxed at about 23.8% currently on that capital gains that you are earning from the difference from what they purchased the house at and for what you're selling it at. So if you think about it, 4.5% versus the 23.8%, that's a big difference. And so it's always wise to consult with a attorney who handles estate plans, specifically a certified elder law attorney, to help make those decisions. Again, in long-term care land, those kinds of transfer of assets are going to be looked at and will count as a penalty if it's seen within the past 5-year look-back period when you are applying for Medicaid. So again, what may have been recommended in tax land may negatively impact you in long-term care land. And again, that is why discussing these things with a certified elder law attorney is advisable. So now some Medicaid myths that we hear. Well, they can take your home. No, they're not going to take your home. There may be things that we need to discuss about your home, but they're not just going to take your home because you're applying for Medicaid. Another thing that you may hear is you have to give your assets away to protect them. Hopefully from the previous slide, you learned that here in long-term care land, assets that you gave away within the past 5 years could potentially cause penalties for you. And so that's something that you would not want to be doing. You don't want to just give your assets away. Or if you give your assets away, you have to wait 60 months to qualify, those 5 years. That also is not true. Just because you gave away a vehicle doesn't mean you have to wait 5 years from when you gifted that vehicle to someone to apply for and qualify for Medicaid. So how do you know if you qualify? Well, again, as I have said earlier throughout this presentation, every case is different, and do not compare apples to oranges. We really need to evaluate your situation, and we have to talk with you about your specific facts, because every puzzle piece in your case means something different. And if we're not talking with you and knowing about all the different puzzle pieces, you may not think something's important, but in the Medicaid world, it's very important. And so we need to know all those different pieces of the puzzle to help make a better, or to have a better understanding of what your situation is. Also, again, with that being said, every case is different. And so if you're talking to someone who's in Texas, their situation's completely different. Or if you're talking with someone and they automatically qualified, but maybe they only had $20,000 as a married couple compared to someone who has $200,000. So by attending today's workshop, by watching this workshop, you are entitled to a free consultation with a team member to be able to evaluate and have that analysis of your specific situation, and to discuss whether VA or Medicaid benefits could potentially be available to you. Can any attorney help? Well, if you needed heart surgery, would you go to a podiatrist? Probably not. So yes, any attorney can potentially say that they are able to help you in the Medicaid world and apply for Medicaid, but do they know all the specifics for Medicaid? It's kind of like how we were talking about the different lands. A lot of attorneys, when they are doing power of attorney documents in estate planning land, they're thinking more tax land items and not so much what happens in long-term care land. And unfortunately, in power of attorneys, there may be limitations that an attorney may not be thinking about that are going to potentially negatively impact you when it gets time to needing to apply for Medicaid in the long-term care world. If the language in your power of attorney document is not sufficient for Medicaid purposes, asset protection purposes, we may not be able to help you. And so I'm going to tell you a true story. A gentleman had come to the office to see Attorney Bellomo, and Attorney Bellomo was going to help him with his power of attorney. And his children knew he was coming to our office for this purpose. And Attorney Bellomo went over everything with him, and he quoted him the fee. And he said, well, Jeff, I can go somewhere else for a little bit cheaper and get a power of attorney document. And so he did. He left and went somewhere else and saved about $75, but it was a business deal to him. He was a businessman. And so he was, about the bottom dollar of what he was getting. And so he went and he saved some money. Unfortunately, the gentleman had a stroke, and the children knew he had come here to our office. And so they reached out to Attorney Bellomo and met with him. And, he said, okay, let's see, all those different puzzle pieces. And the gentleman no longer had cognitive capacity to make any changes to his existing power of attorney. And he had assets that were several $100,000. So he had assets to be protected. And Attorney Bellomo said, now we need to look at the POA. And they said, well, wait a minute, you did the POA. And he said, no, your dad decided to go somewhere else. So they went and they found the POA document that Dad had done in another office that was not a certified elder law attorney, and brought it to Attorney Bellomo, and he reviewed it. And unfortunately, the language was not sufficient to be able to help them protect assets. And he no longer had cognitive capacity to make the revisions. And so unfortunately, he up front saved $75, I believe it was, but in the end, he lost several hundreds of thousands of dollars to the nursing home that could have been protected had the language in the power of attorney document been sufficient. So, can any attorney help? Well, not necessarily with estate planning and also with Medicaid, because they're not necessarily thinking about all the different factors that go into play. Now what? Now we're going to get into the real nuts and bolts of Medicaid, and we're going to talk about all those specifics related to documentation and what is needed to be gathered and collected. It's a lot of documents, and the one word I like to say is that this process is overwhelming in all capital letters. I don't want that to scare you. I just want you to know that that is a normal feeling that we hear all the time. So you're not alone when you feel overwhelmed in this process. But the documentation collection is rather large. It will contain personal documents, medical documents, health insurance information, residential information, life insurance, burial, motor vehicles, and all of your resources, all of your financial accounts are all a part of the document collection. And we're going to go into each one in more detail now. For personal information, what documents are needed? One, we need a photo ID, and these documents that I'm going to speak about are for both spouses in a married case, not just the spouse that needs care and that you're applying for Medicaid for. So a photo ID copy front and back for both spouses, birth certificate for both spouses, Social Security card front and back copy for both spouses, marriage certificate, a divorce decree, a death certificate, power of attorney document, and if you were in the military, the discharge paperwork, a DD-214 form. Now, why do you think we need information on your divorce decree? Well, we need to make sure that you're not either paying alimony or receiving alimony. So we need to know what the terms of the divorce were. As far as medical and health insurance, what documents are needed? Again, for both spouses in a married case, we would need a copy of the Medicare card, front and back. All health insurance cards and prescription cards, front and back copies for both spouses. The health insurance premium notice is also needed. Now, sometimes people will ask, well, can I just show you my bank statement because it's automatically withdrawn? Unfortunately, no, you cannot. We will need documentation, whether it's the coupon book that shows, how much you pay monthly, or a letter from the company that tells us what the premium is. We also need the premium divided apart if it's lumped together in a married case where, maybe you pay $250 for both spouses at one time, we need to know that $150 is for this one spouse and $100 is for the other spouse. We will need to have it divvied out. If you are in a nursing home, we will need a copy of the nursing home invoice or the bill. And also we will be talking with the nursing home regarding the medical review, or basically the form that will tell us that you are truly nursing facility clinically eligible, making sure that you are meeting that medical eligibility qualification need that has to occur in order to apply for Medicaid. What about your property? What do we need to know about your property? Well, we need to know about all of your properties if you own multiple properties, even if it's just a piece of land and there's no shelter on it in the state of Nevada. We still need to know about it. If you have rental properties, we need to know about that as well. So all properties we will need to know about. And as far as documentation, any property that is owned or that your name is on the deed, even if you share it with, 6 other family members because it's a cabin or because your parents passed it down to you and so all the siblings inherited the house, we would need to have a copy of the deed. We also will need to have the current tax bill, the school property tax and the real estate tax for each property owned. If there is a mortgage, we will need that as well. If there are any loans or liens, home equity line of credit, we will need those statements. And for loans, we will need 5 years worth of the statements, again, because we have to evaluate what's been going on with those assets that you may be obtaining from the loan. If there is a property appraisal, we would like to have a copy of that. You don't have to have your property appraised, but sometimes people choose to do so. And we would discuss that with your specific case. Also, if any properties have been sold within the past 5 years, we would need the settlement sheet or the HUD sheet for any property that has been sold. Also, for your actual shelter where you live, we need to know your utilities. And so we want the most recent utility bill. We don't need 5 years worth, just the most recent for electric, gas, oil, sewer, water, your trash bill. If you rent, we would need your a copy of your rental agreement and your renter's insurance as well. Again, utilities are only for the residential property. If you own other properties, we would not need the utilities for all of the other additional properties. What about income? What do we need to know about income? Well, we need to know what your benefits are from Social Security. And so around December timeframe, you normally will receive a letter in the mail from the Social Security office that will tell you what your upcoming benefits will be for the new year. And so we need that. That's called a Social Security award letter. And that will tell us what your gross benefit is, deductions, whether you're having any federal tax withholdings or your Medicare that is being deducted from Social Security benefits, and then what your net benefit is. If you have a pension, we need to know about that. Annuity incomes, dividend incomes, IRA distributions, interest income, disability income, rental income. If you're still working, we need to know what your wages are, if you're salary or hourly, and also then if you're full-time or part-time. And we'd like to see pay stubs for about 6 months to 1 year if you're working and not salary, especially if you're part-time, because your hours may fluctuate. 1 week you might be 10 hours, the next week maybe you're 26 hours. So we just kind of want to be able to see what your hours are and what income you are bringing home. Also, we look at the income tax returns for the past 5 years and the 1099s that are associated with those tax years. Life insurance. So what do we need to know about life insurance? Well, we need to know about every single policy that has been in existence for the past 5 years, even if you've let it lapse or surrendered it, or if it's current and still active. We need to know about all the policies. If it's still a current active policy, we would want to know what the face value is, the cash surrender value, and the death benefit. Again, if any have been surrendered in the past 5 years, it's during that 5-year look back time frame, so we would want that information as well. One thing to remember when you are dealing with life insurance companies, especially if you are the power of attorney dealing with the life insurance company, it's really important to always make sure that you are sending in your copy of your POA every time you are sending in a new form or requesting additional information, because we've had situations where the POA has, made contact with the life insurance company. They've already sent in their power of attorney document and they assume everything's good. The company's talking with them. They're sending them the information they need. And then they go and they fill out a form such as maybe a change of ownership form, or maybe a beneficiary form, or a surrender form. And they submit that. And they wait and they wait and they wait and they don't hear anything. And they contact the company and they said to the company, the representative that they're talking to, I sent this form in 4 weeks ago and I haven't heard anything. And they check into it and, well, you didn't send your power of attorney document with it. Well, you already have it on file. Well, we know, but it wasn't attached to this form, so we can't honor this form. So always make sure that you are sending in a copy of your power of attorney document. Motor vehicle information. What type of information is needed? And it's not just about motor vehicles. It's about anything that would have a title. So a camper or a boat. You have to not just think about, the car that you're driving every day. It could also be the vehicle that's been in the garage for the past 25 years that is rusted out and no one's obviously been driving it. That's still an asset that we would need to know about, that Medicaid would need to know about when you are applying for Medicaid. And so regarding those types of assets, we would need to know or have a copy of the title and registration, the model, make of the vehicle, the mileage on the vehicle, and this also pertains to any vehicles, boats, campers that you have traded in, gifted, given away, sold, whatever it may be in the past 5 years. So it's not just what you currently have, it is what you have had in the past 5 years, and if you have disposed of them and how you disposed of those vehicles. Was it gifted to someone? Was it junked at the junkyard? Was it totaled in a car accident? We would need to find out those items. Resource information. If it's a financial asset, we need to know about it, whether it's cash on hand, whether it's savings bonds, money markets, stock certificates, savings accounts, checking accounts, money markets, brokerage accounts, CDs, credit union accounts, Christmas clubs, Roth IRAs, 401ks, IRAs. We need to know about every single type of financial asset that you have. If you have a trust, we need to see the trust document. We need to figure out if it's an irrevocable trust or a revocable trust. We have to identify what is funding the trust. What did you put in the trust? How long have those items been inside the trust? At the beginning of the presentation, we were talking about estate planning, and we were talking about potentially putting your assets in a trust. And so we do, estate planning, you're kind of doing some pre-planning, and maybe you put your things in a trust. But maybe you didn't get 5 years down the road, before you had a stroke. Well, what happens? Well, the attorney is going to evaluate where we are in the length of when you placed items into the trust, when you funded the trust, from when, you started your estate planning, pre-planning route? And did you make it 3 years? Did you make it more than 5 years? Where are you in that path? And if you didn't make it to the 3-year mark or 2.5, 3-year mark, what's going to happen? Well, the attorney may decide that, we need to back down and go the other route. Again, it doesn't mean that you did the wrong thing by going and trying the trust route. You may just not have gotten the biggest bang for your buck, basically, because of timing. It didn't work out. But if you do have a trust, we do need to see whether our office did it or someone else did it. We would need to see what is funding the trust and what financial accounts are in the trust, what properties are in the trust. So we need to have that information as well for Medicaid purposes. And then we have to verify everything. We have to look at those financial accounts page by page by page. We need every single page of the financial account statements. So even if it's a 40-page statement, we need all 40 pages. We realize that some are just advertisements or verbiage, but the county assistant's office will want to see every single page to ensure that nothing is being missed when they are reviewing the documents. And honestly, when we are reviewing them to protect asset protection, we also need to make sure that we are looking at every single page and every single line. So we would also need that information. What are we looking for? Well, we are looking for transactions of $500 or higher. And then we want to know, basically what happened to those funds or where did you get those funds? So we may request copies of checks that are $500 or more. We also will request deposit slips and all associated documents related to that deposit. So what does that mean? Because most people don't keep their deposit slips. Well, what that means is that you'll have to most likely go to the bank and ask them for the deposit slip, a copy of it, and the associated documents. And if the deposit slip was filled out that $600 cash deposit, we're going to ask, where did that $600 cash come from? But if it's filled out with, on the check section that $800 was deposited, let's say, we're going to want to know and have a copy of that check that was deposited, which the bank will be able to obtain for you also. But this way, we will know where that $800 check came from. Was it from a car accident and the car was totaled and this was the settlement? Or what was it from? Was a life insurance policy surrendered? So we would want to know where those other assets came from. Again, this is for the full 5-year look back from when you are applying for Medicaid. And until we have all of that information, we can't move forward with applying for Medicaid. Again, I've said earlier, we have to have all those different pieces of the puzzle to be able to know everything and put your financial plan in place if we're able to protect assets for you. Once we have all those pieces to the puzzle and we're ready to move forward, we will then have you sign all necessary legal documents for your plan. We will also implement the financial plan if we are protecting assets for you. We will have you sign the Medicaid application documents and the other associated documents that go along with that, such as a resource assessment, if applicable, and that would be in a married case. And then we prepare everything and we get everything down to the county assistant's office for their caseworker to review. And it's a little ping pong game, as you can see, that goes on. And where it says applicant, that's more our office. We are the ones corresponding, if you retain our services, with the caseworker. And then we'll notify you and let you know if anything additional is needed. So what happens while the file is at the county assistant's office? Well, they're going to look at these applications as promptly as possible. And really within 30 days, they should be notifying our office of what is their thought on the application as far as if additional documentation is needed to prove everything, or if they have any questions on any part of the financial aspect of the account, or if they need anything further. And really within 45 days, then we should have a determination on whether they approve your case or they are denying the case. And if the county office is unable to make a decision within the 30-day period, it may extend. And again, we're going to be notified as to what is still needed. And once we, get that notification, we can make a decision if we agree with them or if we disagree, and if we would need a fair hearing with an administrative law judge. Hopefully, we right away will get a favorable decision though, and in that decision on that notice, it will state the effective date. It will state how much of your income has to go towards your cost of care, because even once you are approved for Medicaid in a nursing home setting, you still have to pay your income towards your cost of care. Now, in a married case, your spouse at home may be entitled to a spousal allowance, and they will look at what that spouse's income is and see if it's below a certain threshold, which changes every year. And if so, then they will supplement the spouse still at home, known as the community spouse, with some of the institutionalized spouse's income. Personal needs allowance is currently $45. So that means that the individual, if there are no penalty periods from any gifting that's occurred in the past 5 years, they would be entitled to $45 that they would get to keep. But you need to make sure that you don't go above what you are allowed to keep in countable resources as the institutionalized spouse. And again, that will depend upon what your income is. If your income is less than $2,382, legally you can keep up to $8,000. If your income is more currently in 2021 than gross monthly income of $2,382, you would only be able to keep up to $2,400 in countable resources. So you don't want to let that $45 creep up and put you over your limit of countable resources to maintain your Medicaid benefits. If we were to receive an unfavorable decision, first it's going to tell us why we are being denied, and it's going to inform us how to appeal the situation. And as long as we appeal the situation within 30 days, we have the right to a fair hearing. So our office would immediately request a fair hearing. And again, we have 30 days from the date of the decision from the caseworker to request that fair hearing, and then we would have that with an administrative law judge. So hopefully you learned a lot today. You probably have some questions though, so if you could please just write them down and bring them along to your consultation. We would be happy to answer them during that next meeting with you. Also, in your virtual booklet that you received, your folder, you should have an evaluation form. We would love your feedback. So if you could please provide that back to us, that would be greatly appreciated. Thank you for attending today. I hope you enjoyed the nuts and bolts of Medicaid, and we look forward to meeting with you at the next consultation. Goodbye.
Hi, thank you so much for watching the Medicaid Workshop video. Since that was last recorded, however, the numbers changed. Every year the numbers change, and now on the screen are the numbers for the year 2025. If someone is interested in the Waiver Program, where the care comes to your home, there is an income cap, and that income cap is now $2,901 of gross monthly income for the individual that needs care. This does include, if someone would have a long-term care policy, how much that would pay out towards the person's care again, regarding the waiver program, there is an income cap, and it is now $2,901. If someone is over $2,901 of gross monthly income, slightly over, there may be some other options that we can pursue and strategies that we can look into if you're interested in the waiver program. And we can discuss that at an upcoming meeting with me. As far as countable resources, how much a person can keep of their countable resources, if they are a single individual in the year 2025 and their income, gross monthly income, is over $2,901, they can have up to $2,400 in countable resources. If their income is less than $2,901, their countable resources can be up to $8,000. Now, in the year 2025, a married couple can keep a different amount that was previously discussed in the video that you just watched. In 2025, the individual in a married case that needs the care, they can keep countable resources the same as the single individual. So if their income is over $2,901 a month, they can have less than $2,400 of countable resources. If their income is less than $2,901 a month, they can have up to $8,000 of countable resources. The spouse that does not need care is also allowed to keep a certain amount of countable resources, and that is based on the resource assessment. And in the year 2025, the maximum amount that the spouse who does not need care can keep is $157,920. And the minimum amount is $31,584. Again, these numbers change every year, but this is the current number for the year 2025. I look forward to discussing your specific Medicaid questions and concerns at an upcoming meeting. Thank you. Goodbye.